Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore a question involving competent and compellable witnesses, a topic in criminal law under FLK2. Let's dive in. A defendant is charged with assault occasioning actual bodily harm after a fight outside a nightclub. During a police interview, he claimed he acted in self-defense because he believed the complainant was reaching for a weapon. At trial, the prosecution relies on CCTV footage and a witness. The defendant chooses not to give evidence and instead relies on his police interview. Is the defendant legally required to testify to support his claim of self-defense? A. Yes, because raising self-defense means he must give oral evidence at trial. B. Yes, because the burden of proving self-defense shifts to the defendant. C. No. He is a competent witness for the defense but cannot be compelled to give evidence. D. No. He is not required to testify because his police interview is already in evidence. E. Yes, because the court cannot consider self-defense unless he is cross-examined. The best answer is C. Under Section 1 of the Criminal Evidence Act 1898, a person charged with an offense is a competent witness for the defense at every stage of the proceedings. However, he is not a compellable witness, meaning neither the court nor the prosecution can force him to give evidence. While a jury may be invited to draw adverse inferences from his silence under Section 35 of the Criminal Justice and Public Order Act 1994, this is a matter of evidential weight rather than a legal obligation to testify. Actual SQE MCQs are usually more detailed and fact-specific than simplified practice question above. In the actual exam, a question may be presented in a format similar to the example below. You should familiarize yourself with this style of MCQ. Legal concept explained in criminal proceedings, competence and compellability are two separate concepts. Please see this table. A competent witness is a person who is legally permitted to give evidence in court. In other words, the witness is capable of testifying if they choose to do so. A person is generally competent if they can understand the questions being asked and give answers that can be understood. If a person is not competent, they cannot give evidence at all. Examples are very young children and person with severe cognitive impairment. A compellable witness is a person who can be legally required to give evidence. If such a witness refuses to attend court or answer questions, the court may compel them to do so. Examples of compellable witnesses include ordinary eyewitnesses to an incident, victims/complainants, police officers, expert witnesses, other professionals with relevant evidence. Targeting a pass in the upcoming SQE1? Knowing the law is one thing, navigating the SQE's tricky logic is another. Our question bank bridges that gap. We offer over 600 rigorous MCQs across FLK1 and FLK2, specifically designed to mirror the actual exam's difficulty. No surprises on exam day, just preparation. Test the quality of our questions today and see the difference for yourself. Start your free mini-mock by scanning the QR code here. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.